Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have another exceptional webinar conducted by Kevin Estevez, dealing with bonded liens and discharge of bonds in Arizona, how to get paid on a public project bond claims in Arizona. So without further ado, I introduce the fabulous Kevin Estevez.
Thanks, Ariella. Good morning, everybody. Like Ariella said, my name is Kevin Estevez, and I'm a partner at Holden Willits here in Phoenix, Arizona. And today we're going to talk about dealing with bonded liens, which are lien discharge bonds in Arizona. And then we're going to talk about how to get paid on public project bond claims in Arizona. So with that, we'll jump right in. Welcome to the webinar. If you have any questions, please use the chat box that's provided, and we'll get to the questions at the end. And we ask that you do not include names and company names in your questions. So before we get started, this is the 5th in our series of webinars we've done on lien and bond claim laws and generally construction law in Arizona. So let's just take a step back and go through what we've covered already. First webinar, we talked about Arizona preliminary 20-day notices, lien and bond claim. We did a refresher with pro tips, and so we'll talk some more today about bond claims specifically. The second webinar we did was what happens after I record my mechanics lien in Arizona. How do I get paid? And there we address the steps of, okay, you get the lien recorded, then you have to serve it, and then you have to foreclose on it within a certain amount of time. Third webinar we did was lien waivers in Arizona. Be careful what you signed. We talked about being very careful when you sign lien waivers. Arizona, as you recall, if you've listened to that webinar, there's statutory forms provided. We have really 4 lien waivers that come into play. We have progress waivers, both conditional and unconditional, and we have final waivers, both conditional and unconditional. And the big takeaway there is do not sign an unconditional waiver until you have the payment that the waiver corresponds to in your hand and that has cleared the bank upon which it is drawn. Then we talked about the 4th webinar, we talked about bad checks and credit card chargebacks and how to deal with them in Arizona. And that brings us to our topics for today, dealing with lien discharge bonds in Arizona. And then once we address that, we'll talk about how to get paid on Little Miller Act bond claims in Arizona. And that brings us back to one of the most important parts of all the seminars, and a recurring theme that I've hopefully made clear and will continue to try to make clear, is that in Arizona, it's extremely important that you serve a 20-day notice, a preliminary 20-day notice on the construction projects on which you furnish labor and materials, or if you're a supplier, you furnish materials, because that opens up your ability to, number one, record a lien on a project, and number two, pursue bond claims in most respects. So again, the statute that governs is 33-992-01, and it says, except for laborers for wages, every lien claimant, and then I added some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice within 20 days of beginning work. And again, you can serve a preliminary 20-day notice later in a project, but it only catches back 20 days. So if it's November 20th or November 21st, and you serve a 20-day notice on a project that maybe started on September 1st, it would catch back 20 days to November 1st, and then you would have lien and potentially bond rights on claims that or materials and labor that you furnished after November 1st. But that period from September 1st until November 1st would not be covered for purposes of lien rights and potentially bond claims. So not serving a 20-day notice, potentially you will forfeit all your lien rights and maybe your bond claim rights. So again, if I can emphasize anything, make sure that you're serving 20-day notices for projects in Arizona. So lien discharge bonds, and I've actually got 2 cases going on right now where these are involved. And the Arizona statutes provide that after a notice and claim of lien is recorded, a property owner has the option of posting a statutory lien discharge bond. And that is essentially a payment bond that is for 150% of the amount of the lien, and it must be recorded in the county where the project is located and served on the lien holder. And once that lien is recorded, that bond is recorded, it discharges the effectiveness of the lien on the property. And if the lawsuit to foreclose on the lien, hopefully, as you work through these things, once a lien is recorded, you're working towards a resolution and get things resolved. If unfortunately it doesn't make it to that point, and it doesn't look like things are going to get resolved, and a bond is recorded after the lien has already been recorded, but before you file suit, then you will have to file suit on the bond, as opposed to, so you make a claim on the bond, and the principal on the bond, who's the contractor that is posting the bond, and you would do that instead of suing to foreclose on the lien. But you still, as is the last point here, you're still going to have to file that lawsuit within the time you would have to foreclose on the lien. And as we talked about before in some of the earlier presentations, once a lien is recorded in Arizona, you have 6 months to sue to foreclose. If a lawsuit is already pending, so if you file suit to foreclose on your lien, and at that point, the owner or the upstream party posts the discharge bond, then you need to amend your suit, and you have, I believe, 90 days to amend that suit to bring a claim on the bond and the principal on the bond. So that's basically how lien discharge bonds work in Arizona. Depending on the project, depending on the owner or the upstream parties involved, there's certain strategic reasons that they are employed, and you just need to be aware of them and know that's an option that you may have to deal with, or a strategy you may have to deal with as a lien claimant in Arizona, and be prepared to react. But even if a discharge bond is posted, it has to be served on you, and it does not elongate your time to sue to foreclose. And that can be somewhat confusing, because we'll talk about in a second the deadline to sue to collect on a payment bond in Arizona on a public project, which would be a Little Miller Act bond, is a year from the time that you last furnish labor or materials to the project. So you potentially have more time to sue to sue on a payment bond versus your ability to foreclose on a mechanics lien. And that depends on what stage of the project you are working, because lien rights expire, or the ability to record a lien, you have 120 days from the completion of project. And as we talked about in the past, the completion of project can be defined in a variety of ways. But you have a 6 months from when the lien is recorded to file suit to foreclose. So don't let that trip you up with respect to timelines. And with that, we'll move on to public project payment bond claims. As we touched on in the past, and we'll go into a little bit more depth today, mechanics liens apply only on private projects, and that's simply for the reason that public projects and the public property to which they apply cannot be liened. And so federal and state law require payment bonds on projects of certain sizes and types. And qualified subcontractors and material men may have claims against the bond if they satisfy certain notice requirements. The payment bonds on federal projects are governed by the Federal Miller Act, which can be found at 40 USC section 3101 et sec, and Arizona public payment bonds are governed by Arizona's Little Miller Act, which is very similar to the federal Miller Act, which can be found at ARS Title 34 or the Uniform Procurement Code ARS Title 41. Federal and state notice requirements differ and depend on contract tier. So we'll talk about first who is protected by Miller Act and Little Miller Act payment bonds under both federal and state projects. Typically, you have the general contractor posting the bond, and if that's the case, the first tier subcontractor is protected, the first tier supplier is protected, and the second tier subcontractor and supplier are also protected. Second tier suppliers are not protected, third tier suppliers are not protected, and third tier subcontractors are not protected. And that gets us to notice. Under the Federal Miller Act, laborers and material men with no direct relationship to the general contractor furnishing the payment bond must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor or furnished or supplied the last of the material for which the claim is made. So on federal projects, you have to give this 90-day post-completion notice to trigger your ability to file suit on the bond. Arizona is a little bit different. In Arizona, a claimant who has a direct contractual relationship with a subcontractor of the contractor furnishing the payment bond, but not a contractual relationship express or implied with the contractor, has a right of action on the payment bond on giving the contractor the following notices. Number one, you have to give a written preliminary 20-day notice, which we talked about earlier, in which I said can affect your ability to have a bond claim on a public project. And then you have to give a written 90-day, and this is similar to the requirements under the Federal Miller Act, a written 90-day notice given within 90 days after the claimant last performed work or furnished materials, stating, number one, the amount claimed and the party to or for whom the material was supplied or the labor was performed. And so one of the key things you'll notice about the constructs of Arizona's Little Miller Act statute is that if you have a direct relationship with the contractor furnishing the bond, you don't need to provide these types of notices. It's not a bad practice to provide the notices anyways. There's no harm in providing them, but you don't need to. And the reason for that is presumably, if you have a direct relationship with the contractor furnishing the payment bond, they're going to know you're out there. The notice requirements, both the preliminary 20-day notice and the 90-day notice requirements, are to protect the contractor furnishing the bond from claims that they may not know about, and from parties that they don't have direct contractual relationships with. So if you have a relationship with a sub of the contractor furnishing the bond, then you're going to have to go ahead and furnish these notices. Under both the Federal Miller Act and the Little Miller Act, claimants may not bring suit to recover on the bond until 90 days after the last labor was furnished or materials were supplied. So you have to provide that 90-day post-completion notice if you're required within 90 days of when you last furnished material or supply labor, but you can't sue before the expiration of that 90 days. And then again, as we talked about earlier, the statute of limitation for filing suit on a bond claim expires 1 year after the date the claimant last performed labor or supplied material. So it's really, if you think about it, it seems like you have a year, but the first essentially 3 months, those first 90 days, you can't sue on the bond. You have to wait for those 90 days to lapse, and then you have basically 9 months to file your suit if things are not resolved. And again, different from lien statutes where you have 120 days after completion to record your lien. You're talking about completion there on the entire project. Here, everything's being measured from the day on which you last performed labor or supplied materials. So that's a different standard there. And with that, those are the topics I had to cover today. If you have any questions, please let me know. And again, Arizona construction law and Arizona law with regard to mechanics liens and bond claims in particular is very complex. So if you do have any specific questions you're facing an issue, I suggest that you please consult with a qualified attorney. And with that, I'll bring back in Ariella, and we can open up to any questions if you have any.
Great. Yeah, if you want to go to the last slide with all of your contact information, great. We had one, this one is a very simple question. First of all, Kevin, great job. Will you receive a copy of the presentation? Yes. Not only will you receive a copy of it, we're going to send out the entire presentation so that you can hear what he had to say on each slide. I don't know if anyone else has any other questions. You can, like he mentioned, the very beginning on the right-hand side were the questions you can ask right there. And if you have a question that you think of after the presentation, feel free to send Kevin, or you certainly could send me an email. All right, well, thank you so much, Kevin. I think that's it. Fabulous presentation, and I wish everyone a sunny day.
Thanks, Ariella. Thank you, everybody.